Hello students and welcome to the lecture. So students, as we know that we are covering the fundamental rights, and in the previous lecture basically we had started the discussion over the writs, right? Like what are the writs, from where we had taken them, and thereafter why the writs are effective to implement the fundamental rights, because they having the immediate command. Thereafter, we had discussed the writs jurisdiction difference between the Supreme Court and High Court. All right. And basically, while we were discussing it, we had find out if we talk about the aspects. So the Supreme Court and the High Court, if we compare them. All right. So the Supreme Court aspect is always narrower, and the High Court aspect is always wider. Why? Because the Supreme Court could only issue it in the case of fundamental rights. All right. While the High Court issued it in the cases of fundamental rights and the ordinary legal rights. Okay, this is the thing we had discussed. And if we talk about the territorial extent, then Supreme Court is having the wider extent, while the High Court having the narrower extent. All right. And we know that the Supreme Court is basically bounded to issue the writs because it is the fundamental rights, while the High Court is not, you can say, bounded, and basically this is totally dependent upon the discretionary powers of the High Court whether they want to issue the writ or not. All right. So that's a thing that we had discussed in the previous lecture. And in the previous lecture, basically we had discussed the writs of habeas corpus. All right. We had discussed that it is a Latin word. Okay. And then we had discussed that basically it is issued whenever there is a case of detention. All right. And there are certain areas in which it could not be issued if there is a lawful detention. Okay. If there is a case of content of legislation, case of content of court, and then the case lies outside jurisdiction of court. Okay, these are the areas. But remember, the High Court could even issue the writs outside the state territory if the cause of action was a judicial tragedy. Okay, if that is the case, then even the High Court could issue the writ out of the state boundaries. Okay, so these are the things that we had discussed in the previous lecture. Now we will start from where we had left. After it, now we are going to talk about the mendamus. Okay, so if we talk about the mendamus writ, so basically it literally means we command. Okay, we command, and this is generally given to release the immediate command. Okay, so whenever there is a case to release the immediate command, always the writ of mendamus issue, because its name itself carries the word we command. It is a command issued by the court to the public official asking him to perform his official duties that he has failed or refused to perform. Okay, so we can say, suppose if there is any public servant, all right, there is any public servant, and the public servant having the duty to ensure safety and well-being of the citizens. Okay, so if there is any case in which the public officer or the public servant either failed or refused to perform his official duties. Okay, here remember we are talking about the official duties. We are not talking about to do the work in the personal capacity. Okay, suppose there is a public servant and some of the person ask him to go to the shop and buy some packet of milks. Okay, because he said that he is a responsibility to serve the people. No, only in terms of official duties, not in terms of personal capacity, the writs could be issued. Thereafter, it can also be issued against any public body, corporation, inferior court, tribunal, or government for the same purpose. Okay, it means that, however, the prime target is the public officers. But apart from them, if there is any public body, if there is any corporation, there is any inferior court, tribunal, and even there is a government which refuse or fail to perform the official duties because of this, someone's fundamental rights got violated. So in such a cases, the mandamus could be issued. The writ of mandamus could not be issued in a cases like against a private or the individual body. Okay, the habeas corpus could even be issued against the private or the individual bodies, but the writ of mandamus could not. Thereafter, to enforce the departmental instructions that do not possess a statutory force. Okay, like if we talk about the departmental instructions, if we talk about the departmental instructions, so basically they are of the two types. The first is the statutory instructions. The second is the non-statutory instructions. Okay, so basically if we talk about the statutory instructions, so they are usually drawn out from the provisions of the Act and regulations. If we talk about the non-statutory instructions, so these are made or drawn out from the provisions which are not a part of Act and regulations and thus made by superiors themselves. Okay, so every department instructions are of these types. If we talk about the statute instructions, so generally they are drawn from the Act and regulation. Like there is a department, so the department must having some official Act and regulations. So if the instructions have been passed and these instructions are totally based on the Act and regulations of the department, then this will be considered under the statutory instructions. And if the department refuses, if someone refuses to obey and fulfill these instructions, then the command of mendamus could be issued. But if we talk about the second case is the non-statutory instructions. They are made or they are drawn out from the provisions which are not a part of Act and regulations and thus made by the superiors themselves. Like these instructions are basically passed by the departmental heads, okay, HODs, and even you can say some superiors. So these instructions are basically discretionary in nature, all right, and the instructions do not have any statutory force. So the mendamus could not be issued against the fulfillment of these instructions, okay, because these instructions are only based on the discretions of the superiors and not on the Act. Thereafter, when the duty is discretionary and mandatory, okay, it means that there is no statutory force in that duty, okay. Thereafter, to enforce a contractual obligation, okay, because it is not a fundamental right but it is a legal right which is covered under contractual agreements, all right. Thereafter, it could not be issued against the President of India or the state of governors. Why? Because we have seen while they were in the you can say office terms, okay, so the two things could not be happen against them. No case could be registered in the courts against them, so that if the case even could not be registered, then how will the mandamus could issue? All right. Second is the like these officers could not be forced. These persons, like the president and the governors, could not be forced to do something in the favor of the people. Okay, they are restricted against the chief justice of a high court acting in a judicial capacity. Okay, so these are the certain areas in which, or you can say against which, the mandamus could not be issued. Like first, it could not be issued against the individual or a body. Second, if the departmental instructions are of the non-statutory force, then the departmental instructions could not be fulfilled. Thereafter, if the duty is only discretionary and not mandatory or obligatory, then the instructions could not be issued. If there is a contractual obligation, then this does not covers under the fundamental right, and this heading basically covers under the Contractual Agreements Act. Okay, so that will be treated differently against the President of India or the state governors. Why? because while they are in office, no case could be registered against them in any court. Okay, so if the case could not be registered, so the mandamus could not be issued. Second, these persons could not be forced to do something for the fulfillment of their official duties. All right, and this is totally dependent upon their discretion. Thereafter, if there is any Chief Justice of the High Court who is acting in a judicial capacity, then he or she could not be forced to do something by any. All right. So these are the areas. Thereafter, the third rate is of the prohibition. Prohibition is an English word which means to forbid. Okay, to stop something which is ongoing. Okay, so it is issued by a higher court to a lower court because it is obvious. Like if we talk about the judicial structure of our country, okay, so there is a Supreme Court, High Court, subordinate. Okay, and this is the hierarchy. Subordinate court comes under the high courts, and the high courts comes under the Supreme Court. Okay, so if there is a case like the High Court passing the commands to the Supreme Court, is it possible? If we look from the hierarchy point of view, it is possible that the High Court could issue the command, and even the subordinate court could issue the command to the High Court. Is it possible from any way? No, it could not be happen. All right, that is the reason that why this will always be from higher court to the lower court. All right, like High Court could issue to the subordinate court, and the Supreme Court could issue to the High Court. Okay, remember this thing. Okay, so it could be issued by the higher court to the lower court or the tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Okay, so basically it is done to forward the jurisdiction in two areas. First area is case which is ongoing already. Second case is case in which lower court does not possess any jurisdiction right. Okay, so if these are two cases, then what will happen? The higher court will stop the lower court. Okay, in the first case, if the case was already running, then the higher court will issue the orders that stop this course. Okay, stop this case and transfer to it. But if the second case is there, the case in which lower court does not possess any jurisdiction and the lower court is trying to register the case and start the listening, then the case will be go to the higher court and the higher court will prohibit it. Okay, so these are the two areas. Thus, unlike mandamus, that direct activity, the prohibition directs inactivity. Okay, like in the mandamus, there is a command to do something, and in the prohibition, there is a command not to do something. Okay, so basically, remember, here is a command to do something. Here is a command not to do something. Okay, two areas are there. Thereafter, The writ of prohibition can be issued only against the judicial and the quasi-judicial authorities. Why? Because these are the only two authorities where the case could be registered and where the judicial actions could be taken. If we're talking about the non-judicial authority, okay? If we're talking about any non-judicial authority, what do you think? These authorities having any right to register the case and run a case or listening and then pass the judgment and all? No, they do not possess anything. So that's why these could not be considered. Okay, so that's why only the areas in which the cases could be carried on, like the judicial and the quasi-judicial authorities, there only the prohibition will be applied. It is not available against the administrative authorities, legislative bodies, and the private individuals or bodies. Okay, why? Because they are not a judicial authority. All right, they could not take up the case, they could not pass the judgments on it. All right, they could only make the rules and regulations, and they could only take the action for implementation. Okay, they could not register the case, they could not run a case, they could not pass the fixed judgment. Remember these ones. After this, the another rate we have the certiorari. Okay, and if we take the literal means of the certiorari, so it means to be certified or to be informed. Okay, so basically this rate is passed to authenticated something. Okay, so basically it is issued by the higher court. Why? Because the higher court will have the authority on the lower court or the tribunal. Okay, and this is basically issued either to transfer a case pending with the later to itself or to squash the order of later in a case. All right, it means that suppose there is a any lower court in which some case was running. Okay, and then the appeal was made in the higher court. Okay, about some malfunctioning, about some malrepresentation and all in the case which has been running in the lower court. Then what will happen? The high court will issue the higher court will issue the writ of certiorari. Okay, to authenticate what is going on. And even there are two things could be done. The first thing is case will be transferred from lower court to higher court. The first thing could be done. Second, higher court quash listening of case in lower courts. So these two things could be done while issuing the certiorari. Thereafter, remember, it is issued on the grounds of access of jurisdiction or lack of jurisdiction or error of law. Okay, it means that if the lower court registered the case and start the listening and the case does not falls under the jurisdiction of the lower court, then this case will be stopped. Second, if the lower court having the lack of jurisdiction and passing the orders and the judgment through the laws of error, then what will happen? The case will be squashed. Thus, unlike the prohibition, which is only preventive, okay, it means that it could only stop. Certiorari could not even stop it, but also transfer the case at all. So does it a curative also. All right. So these are the things. So students, basically in this lecture, we have finished till here. In the next lecture, we will continue from here. Till then, just revise the facts and figures in the proper manner that we have studied so far and be ready for the another lecture. Okay. So with this note, let's end this lecture and thank you.